Well, it's 4 o'clock. Good afternoon and welcome to this Francis Taylor Building webinar on part 3 of the new Business and Planning Bill. For those of you who don't know me, my name is Richard Honey. I'm a barrister at Francis Taylor Building and I'm going to be chairing the webinar today. I'm very pleased to see that so many of you have booked and logged in for the webinar today. We're going to try to keep it simple in terms of the technology. We're going to take questions via the Q&A function on the system. You should be able to access that by clicking on the icon at the bottom of the screen. The Q&A icon appears when the cursor is over the bottom of the screen. So please feel free to type in questions and comments as we go. We're going to answer questions in a block at the end after the talks, all of them if we can, or certainly as many as we've got time for. We're going to stop at 5:30 if we've not got through all the questions, but feel free to email us afterwards if you've got any burning questions outstanding. In terms of the technology, please don't try to use the chat function. That ought to have been disabled, and similarly raising the hand won't get you anywhere either. Q&A, please. All being well, our speakers will be able to share their screens to show PowerPoint presentations during the talks, but we're also going to email out copies of the slides afterwards, and we're going to be recording the webinar and publishing the webinar recording afterwards. So as I say, the topic is part 3 of the new Business and Planning Bill. The long title of the bill is a bill to make provision relating to the promotion of economic recovery and growth. And it arrives, of course, in the context of the coronavirus emergency. The explanatory notes to the bill say that the bill includes a range of measures designed to help businesses adjust to new ways of working as the country recovers from the disruption caused by COVID-19. And in relation to planning in particular, it says the bill is going to ensure that the planning system can continue to operate effectively and support the safe construction of new developments following the impacts of COVID-19. Now, as you may know, the bill is being fast-tracked as legislation. The House of Commons did the second reading, the committee report stages, and the third reading all in one day, the 29th of June. The bill is now in the Lords, and the timetable is for a second reading on Monday, the 6th of July, and then through to the third reading on the 20th of July. I advised MHCLG on some aspects of the legislation, so I'm not going to be saying anything on the substance of the bill today. I'm acting purely as chair. That means, of course, that I get to put your tough questions to our speakers and avoid having to answer any of them. We've got 2 presentations this afternoon. First, Conor Fegan is going to be giving an overview of the provisions of part 3 of the bill. And then secondly, Daisy Noble is going to be discussing in more detail how the additional environmental approval system works. I'm going to introduce the speakers as they come to speak, starting now with Conor. Conor joined Chambers in 2019. And is doing very well already. He's already appeared alone for a defendant in a substantive judicial review hearing, for example, and is building up wide experience of planning, environment and public law. And as well as being one of his pupil supervisors, I've worked with Conor on a number of cases, including a couple for MHCLG, and I can tell you that he is truly brilliant. So with that, by way of an introduction, Conor, and hopefully not setting unrealistic expectations for you, I'll hand over to you for your presentation, please.
Thank you very much, Richard. Good afternoon, everyone. So as Richard has said, I'm speaking this afternoon about part 3 of the bill, dealing with the planning provisions and giving an overview of those. Starting then in very broad terms, there are 4 main planning parts to this bill. 3 of them are temporary and 1 of them is permanent. The first, relating to construction working hour conditions, is temporary, and the extension of certain permissions and consents is also temporary. There are provisions relating to the holding of hybrid appeals, which are permanent changes. And finally, there are changes to electronic inspection of the London Plan, which is also a temporary provision. Turning to the first of those, then the modification of construction working hours. Before I go to speak about what the bill does, I think it's worth taking a step back and thinking, what is the problem? The problem really is that planning permissions are often, as we know, subject to either a condition which itself restricts working hours, or a condition requiring the approval of some document, normally in the form of a construction management plan, and that document then itself contains restrictions on working hours. And ordinarily, there are good reasons for those conditions and restrictions being imposed. In particular, issues of residential amenity often arise, and impacts on the environment. However, due to the pandemic, a lot of time has already been lost in construction terms. Most of the major house builders, for example, down tools for around a month and a half at the beginning of the pandemic, and aren't currently back to pre-pandemic levels. And indeed, a lot of time is still going to be lost moving forward. If you take a brief look at the social distancing guidelines for the construction industry, for example, it's quite clear that capacity on construction sites will not be back to normal levels for some period of time. And recognizing that time is all important in the construction industry, particularly as it relates to viability, there is a need to make up for lost time. And the way the government thinks that we can do that is through the modification of construction working hours conditions in planning consents. Now, ordinarily, the solution to restrictive conditions in respect of construction hours would be to make a Section 73 application, simply trying to vary those conditions. But that does have some downsides, which I think are particularly prevalent in the current context. There is a cost associated with those applications, although it is relatively minor. The length of time it's taking to process applications at the moment is something that is troubling quite a number of individuals. And also the potential for consultation with statutory bodies under the DMPO when a Section 73 application is made. These were all recognised by the Minister on the 13th of May 2020 when he made a written ministerial statement on construction hours, urging local authorities to take a sensible approach with the aim of determining applications within 10 days. However, as you see once you look at the bill and particularly the background documents, that really didn't go far enough, and MHCLG felt and the Minister felt that there was a need for a swifter, streamlined approach to requesting temporary amendments to construction working hours in order to provide certainty, in particular for those developers and house builders of all sizes. So with that, by the way of background, the bill inserts new provisions into the Town and Country Planning Act, which provide for, as I've said, a streamlined application process for modifying construction working hours in respect of certain permissions. So the first question then, what permissions does this apply to? Well, as I outlined at the beginning, firstly, those permissions which have a specific condition imposing restrictions on construction working hours. And secondly, those conditions which require permissions which have a condition requiring the approval of a document. That document is then approved, and the approved document contains restrictions on construction working hours. So those are the two types of permission that this applies to. It is worth noting it doesn't apply to mining operations. There's a specific carve out in that, or to relevant development of a dwelling house, which is defined within the legislation quite narrowly, and essentially relates to small scale, individual style ancillary development. In terms of making the application then, anyone with an interest in the land or a person acting on behalf of a person with an interest in the land simply applies to the local planning authority, and they can apply for an increase in construction working hours for particular days. So for example, if the condition says you can only work between 9 to 5, you might seek an extension from 9 to 8 o'clock, for example, or you can apply for an increase in days. So for example, you might only be permitted to work Monday to Friday under your current conditions, and you might seek an extension to work on Saturdays as well. And indeed, you can mix and match and have a little bit of both. In terms of making the application, has to be made electronically and not going to be accepted in writing. And the statute outlines certain specified information that has to be included with the application. And it includes the following. You must say what the current restrictions are on your working hours. You must say what you want. You must give a date on which you propose that the new hours should take effect. And that can't be any earlier than 14 days from the day when you make the application. And we'll see in a moment why the 14 days is important. And then the dates when the proposed hours should cease and revert. And that must be no later than the 1st of April 2021. So essentially, how long do you want the extended hours to apply for? And of course, as I've said there, it does revert back. So after the 1st of April 2021, it will revert back to whatever the conditions say at the moment. In terms of the determination of that application, then the planning authority has 3 options. It can approve in line with the application, it can reject outright, or it can make what's called a determination in respect of the application. And really the determination is linked to 3 aspects of the application. It can make a determination about the hours which you're seeking an extension to. So for example, if you have sought an extension of time from, as I said, 5 o'clock to 9 o'clock in the evening, the planning authority could make a determination to say, actually, we think it should only be until 8 o'clock. Or it might make a determination in respect of days or something like that. It can make a determination in respect of the proposed start date, i.e. when the new hours should kick in, or the proposed end date, i.e. when the new hours should cease and revert. There are some limitations in the determinations a planning authority can make. So for example, it can't impose more stringent conditions through the application process. So you're not going to lose out when you make an application. And crucially, and I think this is really a key point, the determination can only be made with the written agreement of the applicant. So if you apply for an extension of time, the planning authority comes back and says, actually, no, we disagree. We think you should only be allowed less time than that. Then the applicant can simply say, well, I disagree. And then it's over to the planning authority either to reject the application outright or to approve it in line with the application made. And of course, as I've put in the last bullet point there is a right of appeal against any refusal. So I think it'll be a relatively bold planning authority in the context who will reject these applications outright, and particularly where the written agreement of an applicant is withheld. You may see a planning authority having some difficulty justifying an outright refusal in those circumstances. Another crucial point, if there's no decision within 14 days of the application being made, then it's deemed to have been approved in accordance with the application. Obviously, the important point there is that this is a speedy process and everything really should be tied up quite quickly. Local authorities have to have regard to guidance issued by the Secretary of State. And just in case you thought there wasn't enough guidance over the past few months, more draft guidance has been published for this purpose. Some interesting points to pick out on the draft guidance. Essentially, there is a presumption that applications to extend working hours until 9 p.m. Monday to Saturday should be granted, unless there's very compelling reasons. So again, that will be quite difficult for the planning authority to justify not following. It goes on to say that 24-hour working may be appropriate in some circumstances. So we are potentially looking at quite significant extensions of construction working hours. It gives some further guidance on what applicants should include with their applications in order to ensure a speedy process. So a short justification document explaining why you need more time and why you're seeking the extension you are. Details of any mitigation that you are willing to implement, and details of any engagement which you've undertaken with neighbours and discussions that might have taken place. It also lists a number of important factors that it says the planning authority should take into account: the nature of the locality, any sensitive receptors. It gives some examples within the guidance. What were the reasons for the initial restriction will be particularly important, and will the extension in hours jeopardise the reasons for the initial restrictions, and any EIA habitats points. So you might be in difficulties, for example, if the reason for the restriction on construction hours was in order to avoid adverse effects on habitats, etc., then it's going to be very hard for you to justify an extension at this stage. So all of those factors relevant, and those are the types of factors you should be addressing in your short justificatory statement. Just some very brief comments just by way of observation. As I've said, it has the potential to be quite a swift procedure for securing modifications with obvious benefits over the Section 73 process. In particular, it's free, and the guidance makes it clear that it is to be free and no fee is to be charged. And there's no statutory consultation provisions. So you're not, although it's open to the local authority to consult with who they want, and they may well consult internally with environmental health officers, there's no DMPO requirement for them to do so. I think in light of the draft guidance and the written ministerial statement, local planning authorities, I think it's fair to say, will be slow to refuse applications. And with the power to modify subject to written agreement, it is very much the case that I think meaningful discussion and negotiation between applicants and planning authorities should be the way forward. It is, of course, time limited to the 1st of April, subject to an extension power held by the Secretary of State. And as far as I can see it, there's very little to no downsides for applicants, so make use of it. As I've said, it's not the case that planning authorities can impose additional restrictions through this process, so you have a lot to gain, and as far as I can see, very little to lose. So turning then to the second aspect of the bill as it relates to planning, and it's the extension of permissions and consents. And this has been a particular problem area throughout the pandemic, and it was identified as such very early on by the development industry. And the problem is obviously that Section 73 cannot be used to extend the life of planning permissions. For planning permissions which were coming to their end during lockdown, you really had two options. The first was to try and carry out a material operation to keep it alive, which was particularly difficult during lockdown. Or your other option was to make a fresh application for planning permission in order to essentially reset the clock with a new permission. And that's particularly risky and expensive and wasn't particularly attractive to developers. Indeed, in terms of the background documentation, MHCLG have given us some statistics which demonstrate just how significant this problem is. They say there's around 1,200 permissions covering a total of 60,000 residential units due to expire on or before 31st of December, and that raises to 83,000 units by March 2021. So really quite a significant problem that clearly justified intervention. So what then does the bill do? Well, Clause 17 it deals with the extension of planning permissions, again inserting new provisions into the Town and Country Planning Act. In very short terms, it's helpful to split this into permissions which are due to expire and permissions which have already expired, because they're dealt with differently. If you have a planning permission which is due to expire between the day when Section 17 comes into force and the 31st of December, then that is automatically granted an extension until the 1st of April 2021. So you don't need to make an application, you don't need to do anything. You have your extension until the 1st of April 2021. However, if the planning permission has already expired and did so between the 23rd of March, i.e. Lockdown day, and the day when Section 17 comes into force, then you can get an extension, but you have to apply to the local planning authority for an extension. That extension would take effect again until the 1st of April 2021. And the local planning authority goes through what's called an additional environmental approval process to decide if the extension will be granted. And Daisy is going to speak in detail about that. But the key thing is, that distinction between due to expire and has already expired. If it's only due to expire, then you're fine. You're getting an automatic extension. If it's already expired, then you have that additional process to go through. And unfortunately, if it's expired before 23rd of March 2020, then tough luck. The legislation is not going to do anything for you. The revival process is particularly noteworthy, I think, insofar as it does go beyond the Scottish provisions, which do provide for an extension of time limits on permissions, but not the revival of permissions. And I think it's really the revival of permissions that have already expired, subject to that additional environmental process, that's really quite noteworthy in this legislation. Turning then to outline permissions, dealt with slightly differently, because there's a little bit more complexity in terms of the conditions that could be imposed. The first set of circumstances then is if you have an outline planning permission that has a condition requiring you to make an application for approval of reserved matters, and that condition requires you to make the application somewhere between the 23rd of March, i.e. again lockdown day, and the end of the year, then you're granted an automatic extension until the 1st of April 2021 for submission of the reserved matters. So again, quite significant there, and that traverses some instances where you may already have ran out of time, and then some instances where actually you're still within time, but you're being granted an extension to the 1st of April 2021. In terms of the other side of the coin, which is conditions relating to having to commence development and outline planning permissions, it's dealt with similarly to what I've just discussed with full applications, and that's this. If you have an outline planning permission containing a condition requiring you to commence development not later than a time falling within the period of the day in which Section 18 comes into force, and the 31st of December, then an automatic extension is granted. So again, that's those circumstances where you haven't ran out of time yet, you're still extant, but you're being granted an extension until the 1st of April 2021. And then again, you have these situations where you have ran out of time, and you've ran out of time between lockdown day and the coming into force of the of Section 18. In those circumstances, again, you have to go through the environmental approval process procedure, which Daisy is going to speak about. So as I've said, it's a slightly more complex approach. It, number one, depends on the type of condition you're speaking about. You know, are you talking about a condition relating to reserved matters, or are you speaking about a condition that deals with commencement of development? And then if it is commencement of development, you again have that distinction between permissions that have already expired and those which are due to expire before the end of the year. And finally then, extension of listed building consents is a little bit more straightforward, thankfully. If they contain a condition which requires works to be commenced not later than somewhere between 23rd of March and 31st of December, then you're getting an automatic extension until 1st of April 2021. No distinction between, as I've said, they're expired and yet to expire. The automatic extension is simply granted. So that leads me on then to the third aspect of the bill as it relates to planning. And this is, as I've said, the permanent aspect of the bill, which is here to stay. Currently under Section 319A, of the Town and Country Planning Act, when you have an appeal, a choice has to be made between an inquiry, a hearing, or written reps. There's no scope for a hybrid approach or a pick and mix approach. It's one or the other. However, the proposals contained within clause 20 do allow for a hybrid approach moving forward. The Secretary of State will be allowed to choose such one or more of an inquiry, hearing, or written representations as he considers appropriate in any given case. So what you might have is some issues being dealt with by written reps, and then some issues being dealt with via a hearing. And obviously that wasn't possible before this legislation. It applies to all standard planning and enforcement appeals, listed building consent appeals, and hazardous substance appeals as well. In terms of those who might be thinking, oh, well, that sounds awfully familiar, it's because it's something that was discussed really in the Rosewell review of planning appeals. In her recommendation 9, Bridget Rosewell was encouraging early consideration of how the main issues should be considered. She was complimentary of the approach that we're all quite familiar with now, which is you have inquiries with certain issues dealt with under in roundtable discussions, but felt that there could have been more utilisation of hybrid approaches to planning inquiries. And of course, that simply wasn't possible until this legislation has come forward. So the proposals do add that extra layer of flexibility and the ability to say some issues are much better dealt with on paper with more limited use of hearing, perhaps. In terms of what that means for us practicing and thinking about these issues, I think we'll all have to sit down quite early on when we're looking at cases and decide, are there issues that will be better dealt with in writing? Are there some issues we think should be dealt with orally? And to reach a judgment on that. That will obviously have implications for costs, in particular, generally speaking, cheaper to have things in the written representation procedure. So again, discussions with clients about how you want to divide that up. And also you need to think about case presentation. Are there issues which you think would be better presented orally than in writing? And if so, that's something you should be pushing for. And if you look at the background papers, again, the motivation as far as the government is concerned for this is very much efficiency. They think that this type of hybrid approach will save time and money and will lead to much quicker outcomes in terms of appeal hearings at PINs. And I think that's needed in light of the backlog that we're likely to have as we emerge from the pandemic. And finally, I said there, for those who practice in Wales, you'll be aware, of course, that there's nothing new. The Welsh provisions already allow for a pick and mix style approach. So this is very much bringing English law into line with Welsh law. Finally, then, and I suppose the narrowest aspect of the bill is changes to inspection of the London plan. Currently, there are statutory requirements within the Greater London Authority Act for physical inspection of the London plan and for the Mayor to provide a copy of the London plan on a reasonable request and a fee being paid. But the new section 43(4)(a) disapplies these requirements. If a copy of the new of the spatial development strategy is available for inspection free of charge by appropriate electronic means, and so provided there's appropriate electronic means, you have no need to have physical inspection for the period specified within the legislation. In terms of what that means, available for inspection by appropriate electronic means, there's a pretty circular definition of that. It says where arrangements have been made such that it is available for inspection by electronic means in a reasonably convenient way. And again, lucky us, there's more guidance issued by the Secretary of State on what that means. And that guidance is currently in draft form and essentially says you have to put it on your website and give some ideas for how to mitigate effects on those who simply cannot access the internet or might find it difficult to do so, and it gives a number of examples within the draft guidance. This is, as I said, a temporary disapplication until the 31st of December 2020. I think it is worth noting it's a relatively limited reform, as there are many examples, and many that people have pointed out for the past few months, of statutory requirements for physical deposit and inspection. EIA regs, for example, require it for environmental statements, local plan regulations when you're bringing forward a new local plan, and nothing really said too much about those provisions. It's interesting that this is the one the government decided that they wanted to reform. So potential missed opportunity perhaps in looking more broadly at doing away with physical deposit and inspection in the current circumstances. If you were to read between the lines, if you look at the ECHR memorandum, so the assessment of whether or not this legislation is human rights compliant, the government is concerned that the requirement for physical inspection might lead to a delay in the publication of the new spatial development strategy. So those who are following it will be aware that the London plan is currently at quite an advanced stage, and discussions ongoing between the Mayor's office and the Ministry on sort of final wording and directions, etc. It may be that there was some concern raised internally about whether the Mayor would be prepared to publish in light of the statutory requirement. So perhaps that's why this has been introduced. And I've said they're an indication of progress. If this is something that's caused concern, then this might indicate that they're coming closer to publishing. But again, that's speculation. And finally, particularly if you look at the ECHR memorandum, there are some interesting comments about involvement in decision making and whether or not it's ECHR compliant not to have physical inspection, etc. That's an issue which has been raised again since the beginning of the pandemic, and I think it's right that it is compliant, provided that there's suitable alternative means electronically. I think what we have seen over the past few months is most people do have access to these documents online. They have shown themselves willing and able to access documents when they need to, and to still be involved in the process. So although those concerns are raised, I think they are validly dealt with. So that concludes then the broad overview of the bill. I'll hand you back to Richard. Thank you very much.
Excellent. Thank you very much indeed, Connor. A reminder that if any of you have questions or comments, please use the Q&A function on the system to ask them. We've got, I think, 10 questions already. We'll turn to those at the end after we've heard from our second speaker, who is Daisy Noble. Daisy joined Chambers in 2018 and has built up a broad planning practice, including both inquiry and High Court work, especially representing local planning authorities in housing cases. I've worked with Daisy on a number of compulsory purchase cases and can personally attest to her excellence and insight, which we're going to see displayed now, I'm sure. Daisy.
Thank you very much, Richard. Good afternoon, everyone. After Connor's introduction and overview of part 3, I'm going to be focusing a bit more on the process for additional environmental approval. So by way of introduction, I think it's worth considering why this process is needed. In short, the process applies to permissions that have lapsed during the period that the UK has been in lockdown. So from the 23rd of March, and that'll run until the date on which the provisions in the bill come into force. And those permissions, as Connor has already outlined, can be revived, but they are subject to this process of seeking additional environmental approval. So what we're considering here are lapsed permissions, and without the additional AEA process, there would be no route by which the environmental impacts of these developments could be considered prior to reviving the permissions. In short, the AEA process provides a means of certifying that there hasn't been a change in the likely environmental impact of the development during this period. And this really reflects the fact that in law, the local planning authority don't have a basis on which to grant permission if the requirements of the EIA and the Habitats regulations have not been met. So this process avoids legal challenge to the decisions to revive permissions, but it also allows compliance with the Habitats Directive and the EIA Directive by providing this means by which local planning authorities can ensure that the developments, that the permissions for which are being revived do comply with those requirements. So the bill provides for the AEA process in clauses 17 and 18, and this will insert a new section 93B and 93F into the Town and Country Planning Act 1990. 93B and 93F are substantially in the same terms in terms of the AEA process, the difference being that section 93F deals with outline planning permissions. And Connor has already explained to you when these provisions will apply in relation to outline permissions. So I've included on the slides the relevant references to both of those provisions, 93B and 93F, but I will deal with them together because they are substantially the same process. So by way of overview, I will be discussing the points that are on the slide there that arise directly from the provisions themselves, before moving on to consider some more practical matters that might arise. So in terms of issues that arise or questions that arise from the provisions themselves, which permissions does this apply to? What is the effective grant? Who can apply? What the procedural requirements are? When the local planning authority should approve the AEA application, the EIA requirement and the Habitats requirement, the time limit for determination of these applications, whether conditions can be applied, and the provision for appeals. So turning to the first question, which is which permissions does the AEA process apply to? Well, the answers provided in subsection 1, it's to full and outline planning permissions in England only, and it applies to planning permissions that are granted subject to a condition which has the effect that all, or in the case of outline permissions, part of the development to which that permission relates, must be begun no later than a time falling within the period beginning with the date on which the UK went into lockdown, the 23rd of March, and ending with the day before that on which sections, as they will be, 17 and 18 of the Business and Planning Act 2020 come into force. So as Connor outlined, the distinction is here between planning permissions that are extended automatically under section 93A and E, because they have not yet expired but would otherwise expire, and these permissions that have actually lapsed and are therefore being revived, and they're the ones that this process applies to. So in terms of the effect of the grant, if the additional environmental approval is granted or deemed to be granted, and I will come to the issue of deeming in due course, the condition that prescribes the time within which development must be begun is deemed to provide instead that the development, or the part as it may be, must be begun not later than the 1st of April 2020. And you should just note that in subsection 2B, it does state that the time within which the development must be begun is not to be extended to a later time than that being provided for in paragraph A, so that's the 1st of April 2021. So it is a relatively short extension. Turning to the issue of who can apply, subsection 3 provides that the only people that can apply are those with an interest in land or a person acting on their behalf. And as one would expect, an application is to be made to the relevant local planning authority. The bill itself provides for certain procedural requirements, and they're set out in subsection 4. So the application must be made in writing to the local planning authority using electronic communications as the local planning authority may specify. The application must specify the date on which it is sent. It must provide sufficient information to identify the planning permission to which the application relates. It must provide sufficient information to enable the local planning authority to identify the condition which would be affected if the AEA is granted. And finally, it must provide sufficient information to enable the authority to determine whether the additional environmental approval should be granted. And just an important point to note is that there is no application fee. So this does mean that in practice, the local planning authority will bear the costs of handling these applications. So turning to the next and very important question of when is it that the local planning authority should be approving the AEA application, and subsection 8 provides the answer to this. And in short, the local planning authority is to grant the AEA if and only if both the EIA requirement is met and the habitats requirement is met. So there is no discretion to grant AEA if these conditions are not met. So I think we'll turn to look at these conditions individually. First of all, the EIA requirement, which is provided for in subsection 9. That subsection provides that the EIA requirement is met either if at the time the local planning authority is deciding the AEA application, no development to which the relevant planning permission relates is EIA development within the meaning of the 2017 regulations, and that's relatively straightforward, or if any of the development to which the planning permission relates is EIA development, the following two conditions are met, which is that a reasoned conclusion was reached and integrated, as mentioned in paragraph 1 of regulation 26 of the 2017 regulations, which I will come to. And in relation to that reasoned conclusion, the authority is satisfied of what is mentioned in paragraph 2 of that regulation. So just by way of a reminder of those regulations, as I'm sure many of you will be familiar with, Regulation 26 concerns the consideration of whether planning permission or subsequent consent should be granted. And subsection 1 of that regulation requires that when determining an application or an appeal where an environmental statement has been submitted, the relevant decision maker must examine the environmental information, reach a reasoned conclusion on the significant effects of the proposed development on the environment, integrate that conclusion into the decision as to whether planning permission should be granted or not, and consider whether to impose monitoring measures. So the AEA process requires that where the development to which the permission relates is EIA development, that it was subject to the EIA process when permission was granted. Further, subsection 2 of regulation 26 requires that the decision maker is satisfied that the reasoned conclusion referred to in paragraph 1 is up to date. So by integrating this requirement from the regulations, section 93B requires the local planning authority dealing with the AEA application to decide, in essence, whether the EIA as originally submitted remains up to date. And an EIA will be up to date if the decision maker considers that the environmental information provided addresses the significant effects of the proposed development on the environment that are likely to arise as a result of the proposed development. Continuing with the theme of the EIA requirement, a potential and potentially interesting issue arises where in the circumstances in which there has been a change in the EIA regulations between the original permission, the original application for permission, and the AEA, because the environmental assessment that accompanied that original application will have been therefore carried out under a previous form of the regulations. So the question that this throws up is, does that matter? And this will largely turn on what the changes are to the regulations that are relevant to any particular development. If the regulations, for example, did not previously require an assessment of an impact, for example, major accidents and disasters, and now, as required by the 2017 regulations, that potential impact is required to be assessed, the EIA condition will not be met in circumstances where the reasoned conclusion that the decision maker previously made on information that didn't include that will no longer be up to date because it will have omitted that particular impact. So that's just an example, but one can see circumstances in which a change in the EIA regulations between the original date of the permission being granted and the date on which you're applying for AEA might produce some difficulties. And in those circumstances, it might be tempting to think that you could supplement the original EIA with further information, but really in these circumstances, as I'll come on to discuss when we look at the practical issues that arise, a fresh planning permission would need to be submitted with new environmental information. And in other circumstances, however, changes to EIA regulations may not render the conclusions out of date. The EIA may still be up to date, it may still cover everything that it needed to cover. So it really is something that is dependent on the circumstances of a particular application, but it's definitely something to be alive to. So moving now on to the habitats requirement, and this is just formulated in a very similar manner to the EIA requirement and provided for in subsection 10. The subsection provides that the habitats requirement is met if a decision with being taken as to whether to grant planning permission at the time that the local planning authority is deciding the AEA application, an assessment would not be required under Regulation 63(1) of the Habitat Regulations. Again, that's relatively straightforward and mirrors the EIA requirement. Or an assessment under Regulation 63(1) would be required, and an assessment was carried out, and it was ascertained that the development would not adversely affect the integrity of European sites, and the authority is satisfied that that assessment remains up to date. So this really mirrors the EIA requirement, but the requirement that that the assessment is up to date sits in the bill itself rather than in the regulations in this instance. So looking at the habitats condition in slightly more detail, Regulation 63, which is referred to in subsection 10, concerns the assessment of implications for European sites, as I'm sure many of you are familiar with. Subsection 5 provides that in light of conclusions of the assessment and subject to considerations of overriding public interest, the competent authority may only agree to a plan or project after having ascertained that it will not adversely affect the integrity of the European site. And subsection 6 provides that in considering whether a plan or project will adversely affect the integrity of the site, the competent authority must have regard to the manner in which it is proposed to be carried out and to any conditions or restrictions subject to which it is proposed that the consent, permission or other authorization is given. Similarly to the EIA condition, therefore, if the development would require an appropriate assessment under the habitats regulations, that assessment must have been carried out. It must have concluded that there is no adverse impact on the integrity of the European site, and that must be considered to be up to date. So an interesting practical issue in relation to the habitats condition that could arise is the consequences of the Court of Justice of the European Union decision in People Over Wind. I'm sure many of you are familiar with this, but by way of recap, the court held that mitigation measures cannot be taken into account when screening for likely significant effects on European sites. And the decision was handed down in April 2018, prior to which it was practice for mitigation measures to be taken into account at the screening stage. So it's likely that there will be circumstances in which the original application for planning permission was not subject to an appropriate assessment, relying on screening that itself relied on mitigation measures that were proposed. And in these circumstances, an appropriate assessment may not have been carried out, but the habitats condition will not be met if an appropriate assessment is now required, taking into account people over wind and not taking into account the mitigation measures at the screening stage. So in these circumstances, a fresh planning permission would be required, and therefore the permission can't be revived under this process. However, there are circumstances clearly in which, despite this decision, even if mitigation measures were taken into account at the screening stage, an appropriate assessment was carried out, and therefore, as long as that's up to date still, the AEA can be granted and the permission revived. So moving now to the issue of time limits, the AEA process as a whole, as Connor outlined, will only last, it's temporary, it will only last until the 31st of December 2020. So no AEA can be granted or deemed to be granted after the 31st of December 2020, unless it's on appeal, and I'll come to that point. In terms of the time limit for determining a particular AEA application, subsection 5 provides that the local planning authority, by written notice, must grant, refuse to grant, or refuse to grant the AEA in relation to the relevant planning permission before the end of a period of 28 days, and that period runs from the day after that on which the application was made. So bearing in mind the combined effect of these provisions, it would seem sensible that to allow a period of 28 days before 31st of December for making your application. It's not advisable to wait until 30th of December 2020 and then submit your AEA application, as the local planning authority won't have the power to grant it beyond the 31st of December 2020. And subsection 7 does provide for extensions of time for determining the application by agreement between the applicant and the local planning authority. However, that is subject to the requirement that the period can't be extended for longer than a total of 21 days. And subsection 6 provides a deeming provision, and this will take effect if the local planning authority fails to determine the application within the relevant time period, so 28 days unless extended. And in these circumstances, the AEA is deemed to be granted. However, you should note that if the application for an AEA does not meet the criteria in subsection 4, which I've discussed, the procedural requirements, it won't be a valid application, and therefore those deeming provisions won't take effect. And that includes the requirement to provide sufficient information to enable the authority to determine the application. The question of conditions, well, this is relatively straightforward. Subsection 11 makes clear that an AEA cannot be granted subject to a condition. So this really means that the applicant either has to show that the environmental assessments are up to date as they are, or it will fail in its application. There isn't scope for granting AEA subject to further investigations or further surveys, so no conditions can be applied. Just several other matters to flag. Subsection 14 provides, as one would expect, that the local planning authority must have regard to guidance issued by the Secretary of State. We haven't seen draft guidance on this yet, so watch this space. Subsection 15 simply provides that a planning permission, subject to a condition providing for the time within which development must be commenced, includes those that are subject to a condition that has been modified. And section 91(3)(b, just by way of reminder, is the extension for a year where planning permissions are subject to proceedings challenging their validity. So turning to the issue of appeals, clause 17(3) inserts new subsections into section 78 of the Town and Country Planning Act, and this creates a right of appeal under section 78 against the refusal of the AEA. And I will come to that a little bit more in terms of the practical issues. In terms of the distribution of functions, the bill modifies Schedule 1 to the Town and Country Planning Act, which concerns the distribution of functions, and it inserts a new paragraph in this schedule, which means that the determination of AEA applications are within the jurisdiction of the District Planning Authority. So, having sort of gone through the points raised by the provisions of the section itself, we're now just going to turn to look at some practical issues, both from the perspective of applicants and from the perspective of local planning authorities. So, first of all, from the perspective of an applicant for AEA, what supporting information is required? Well, I think it's important to bear in mind that the burden is on the applicant to provide sufficient information. And insufficient information may mean that the application itself may be invalid, and providing information that simply doesn't show that your assessments are up to date will lead to a refusal. And so an applicant can't rely on the local planning authority doing investigations for itself or gathering any information. There isn't provision for the local planning authority to consult. So really, the supporting information needs to be gathered by the applicant themselves. And quite clearly, the information will need to be focused on demonstrating that the assessments that were originally submitted remain up to date. And what in practice that will mean is preparation of a report that demonstrates this. And in terms of what will be required, it will really obviously depend on the circumstances, but it might involve demonstrating that there haven't been any material changes in conditions since surveys were carried out, or any new environmental receptors that would have had to be considered. You also might want to think about changes to designations or conservation objectives, and changes to background levels in terms of air quality, or any new development that would have to be taken into account in cumulative assessments. And as I sort of alluded to earlier, it may also involve demonstrating that any changes that have taken place to the regulations don't render your assessments out of date. So this gives rise to the question then of, if your surveys and your assessments are out of date, what to do, and is there any scope for supplementing it with further surveys or updating that information? And in short, it seems the answer really is no, because the question is a narrow one, and that is, were the assessments that were carried out up to date, put very simply. And so where an assessment is not up to date, it's not really the role of this process to be considering extensive new information or really any new information to bring it up to date. The answer to the condition will be the condition is not met, because they won't be up to date. But what about consulting bodies like Natural England? Obviously, these bodies have schemes that you can pay for the consultation views of these bodies, and it may well be in certain circumstances a sensible route to take, but where it is considered helpful, it will be for the applicant to seek. It's not something that the local planning authority will do for themselves. So turning to this issue of what about the submission of a new unilateral section 106 and whether that could assist in the process? I think the issue really is whether it could be taken into account in the AEA process. And it doesn't really appear to me that it could be, because the conditions set out by the provisions are relatively narrow, And suggesting that a new section 106 would be required in some way does seem to be tantamount to accepting that the original assessments are not up to date and therefore the conditions are not met. And clearly the section 106 can't be offering any new mitigation, and it can't be remedying any issues with the assessments. So really the question is a narrow one, and I don't think that would provide a particularly helpful response. So in terms of what happens if your AEA application is refused, do you submit a repeat application or do you appeal? Where your application is refused, there is obviously provision made for an appeal. However, in practice, there may be little merit in the appeal, and that may take some time to be determined, within which you lose your right to make another application because it will be too late. It will be after the 31st of December. So in practical terms, it may be more sensible, if the AEA is refused, to simply reapply with more robust information. Clearly, however, if you are in the circumstance where the AEA has been refused and you're running to the end of the period for making an AEA application, an appeal may be the only route available. So turning to some practical issues for local planning authorities dealing with these applications. First of all, standing back, what is the scope of the question that the local planning authority is going to have to face? And the answer really seems to be that it's a pretty narrow one. It basically turns on determining whether the assessments are either not required or they remain up to date. So this shouldn't really involve looking at extensive information, and it shouldn't really involve the local planning authority having to gather any information at all. So to that extent, the role of the local planning authority is limited by the scope of the question itself. And the local planning authority will be having to consider the development as permitted, and that means with the section 106 submitted and with the conditions that were attached to it and in that form. There is no provision made for any consultation of any bodies, so that really means that it implies it's not going to be the role of the local planning authority to be carrying out consultation. As I said, if bodies such as Natural England are to be consulted, that really will fall to the applicant to arrange. And related to this, it's not going to be the role of the local planning authority to be producing any information. That really falls to the applicant. Just a point for practice. It's likely that most of these decisions will be made by officers under delegated powers. So one point to consider is whether the current schemes of delegation that a local planning authority have in place are sufficient to allow for this, because they are in general enough terms that decisions of this sort can be delegated, or whether any amendment needs to be made to the schemes of delegation to allow this to happen. And finally, there is no requirement in the bill to give reasons. However, in practice, the local planning authority will probably want to record decisions in a document. And it's also worth bearing in mind Regulation 7 of the Openness of Local Government Bodies Regulations 2014, which does require a written record of delegated decisions taken by an officer, including the reasons for the decision, and to be made available to the public. So that brings me to the end of my presentation. We'll have to watch this space for the draft guidance.
Excellent, Daisy. Thank you very much indeed. So we'll switch into the questions session now, and we'll keep going through as many as we can in the time we've got available. I'm going to start with a number of questions for Connor. And the first one relates to conditions governing working hours on developments which are already existing, but are necessary for the construction process. So the example we've been given is a concrete batching plant. So not a building site, but effectively a site producing concrete for using in the construction industry. Do you think that they are able to use this process to extend working hours? And if not, how a local planning authority should look on an application seeking to change working hours under the general provisions?
Yes, thank you, Richard. So I think it turns upon really the wording in particular of the particular condition. So again, we have to look closely at the Act, and what we are looking at is conditions that specify times during which construction activities may be carried out. So there is a question there initially about whether or not the application which we've been referred to actually falls within the scope of the provisions. It may not actually fall within the scope of construction activities. That's an initial question you would need to consider. I think, you know, given the example of a concrete plant, I think that's debatable. So I think that initial question would have to be answered. If you were within the scope of construction activities, then you would, I think, be in fairly strong grounds to be pretty robust with the planning authority in saying, look at the guidance. It says that any extensions until 9 o'clock Monday to Saturday should be allowed unless there's very compelling circumstances, and you have your argument there. But I think there is a legitimate question about the scope of construction activities in that context.
Thank you. There's a question in relation to what happens if no decision is taken within the 14-day period following an application in relation to working hours. Could you just clarify that, please, Connor?
Yes. So as I said, there is a deemed permission given if no decision is made within 14 days. I think an issue was raised about, well, what if you have a determination by the local planning authority? So let's take, for example, you've put in an application and your application is for an extension of your hours from 9 to 5 until, say, for example, 9 to 9. Let's say the local authority comes back to you and says, well, actually, we're making a determination that it should be 9 to 6. But you as the applicant you don't want to agree to that in writing. Again, an interesting question then arises as to what happens. What the statute says is that there must be, you know, the planning authority must give written notice under the first sub-paragraph within 14 days. And written notice includes, for example, making a determination. But when you go down the statute, it says that the local planning authority may make a determination only if there's written agreement. So query in a circumstance where the planning authority has offered forward a determination within 14 days, but that determination is then not accepted. Have they actually made a determination? Because under subparagraph 3, they can only make the determination as far as it's a written agreement. There's two ways to read it. One way is you would say, well, if there's no written agreement, the determination isn't valid. And then you fall back to a circumstance where they have to either accept or refuse within 14 days. The other way to look at it is to say, well, it's a valid determination that's been made within 14 days. And then, you know, if that is not accepted in writing, then you fall into some form of negotiation about, you know, should you accept or reject after that. I suppose the problem with that interpretation is it just leaves you in a situation where there's no fixed time limit for the decision then, when clearly the intention behind the statute is for rapid decisions to be taken in a streamlined process. So again, I think that raises an interesting point that would need to be considered in some detail if it did arise.
Thank you. And there's one question in relation to whether when an authority is deciding to allow extended hours, whether it would be reasonable to ask for ongoing noise monitoring during the additional time that's allowed.
Yeah. There's no provision made within the statute for specific conditions to be imposed upon the sort of grants of extension to construction hours. So it's not that a local authority can come along and say, well, unless you do this and we're going to condition it, we're going to refuse you. That's not possible. However, as part of a negotiation with a local planning authority, you may well say we are willing to voluntarily agree to some form of noise mitigation measures. You might, for example, want to offer that up in a section 106 or something along those lines. Or you might simply say, look, we're willing to do this. That might then persuade the authority that that's a sensible approach to take. The draft guidance is quite clear that you should be offering mitigation where you can. So again, that's something for you to discuss with the local authority, but it's not something the local authority can impose unilaterally on you.
Thank you, Conor. And there's a question as to whether the Section 96A procedure for non-material amendments in the 1990 Act might have been suitable for dealing with the problem of construction working hours. Do you have thoughts on that?
Yeah, I mean, it's possible in principle. It can be used, but I think the reason why it hasn't is, again, there's a fee associated with it. If you look in the DMPO, there's specific requirements in respect of consultation, etc. So short point is it costs money, would take a lot of time, so it's not really suitable for what the government wants to happen here.
Thank you. We've got a couple of questions that relate to what should be done about a planning permission which is due to expire shortly, and a question asking what the view is in terms of the timetable for royal assent, given that we know we've got the third reading coming up towards the end of July, and we can assume that the parliamentary timetable will continue with that third reading on the 20th of July. But do you have thoughts, Conor, on when you think royal assent will be and what to do with a planning permission which might be expiring shortly before that?
I mean, it's always difficult to guess with these things. It very much does depend on whether the Lords want to use this as an opportunity to include provisions that go beyond what this bill is specifically dealing with. I think in respect of these particular provisions, it's probably unlikely that there's going to be a huge amount of changes to them or a huge amount of controversy. But in terms of what the Lords may tag on to this bill and discuss under this guise, I simply don't know. I have seen some suggestions that we could be looking towards the end of July as the estimate by some people before this all kicks off. I've also seen some suggestions that arrangements are in place for royal assent to be given quite rapidly after it goes through Parliament. But in terms of what happens in Parliament, I mean, that's really a guessing game at this point. In terms of those permissions that are going to expire soon, obviously these provisions are in place. You know, you can read, well, they're not in place at the moment. That's the first thing to note. So you're taking a gamble if you decide to just wait out the parliamentary procedure and hope that the provisions as they currently are going to be enacted. The much safer approach would be for you, given that we are emerging from lockdown and construction workers can go into work, would be to implement the permission, which really isn't too difficult in terms of what you have to do under the statute. So I think to be safe, you'd be much better implementing your permissions instead of waiting for this legislation to come forward. Once the legislation does come forward, I think given the circumstances, it's likely you will be able to benefit from some form of extension, whether or not that's automatic or requires you to get approval. It simply depends on what the time limits involved are.
Excellent, thank you. So a few questions now for Daisy. There's a suggestion that if there's planning permission for a development where AEA is required, which is obviously not subject to EIA and Habitats regulations assessment, it's going to simply be rubber stamped by the local planning authority. Do you think that's a fair prediction of how this is going to work in practice?
Well, clearly there will be cases where it's much more straightforward, and therefore both the EIA and the Habitats conditions can be sort of seen to be met very easily. So yes, I think there will be some cases, although the local planning authority will obviously have to consider it and consider any changes to regulations, etc. But I can see that there will be some cases in which it will be pretty straightforward.
Good. And there's a question just asking for clarification that when there's a grant under this additional environmental approval process, that the result will not be a new planning permission. And I just wondered, Daisy, if you wanted to say something more about that.
Well, it is a slightly odd sort of process in a way, because you're reviving a planning permission, and it's sort of slightly like a hybrid between an extension and a new planning permission. But I think was the point there about SIL liability? Was that the point? I might be jumping ahead.
No, that was right.
But no, it's not going to be. I mean, I haven't thought about the issue of SIL before this, but I would be very surprised if it had implications for the SIL calculation, because as I sort of explained, you're not looking at the section 106, you're not revisiting that, you're not revisiting any aspect of the development as permitted, you're just assessing it as permitted with its conditions, with its section 106, etc. So that would be my feeling on that point, at least.
So it's almost as if by statute someone has got out some TIPEX and changed the implementation date on the original permission, but otherwise everything else is still the same. Is that right?
Yeah, absolutely. Because I mean, what the effect actually is to change a condition on the permission. So it isn't granting a new permission, even if it may look slightly like that in practical terms. But no, it is doing exactly as Richard said. TIPEXing out the date and adding a new one.
Excellent. And there's a question in relation to a reserved matters application, a situation where an application for the discharge of reserved matters has been made but not dealt with, and they're wondering whether or not that could be withdrawn and then a new one made. In light of the proposed changes under the bill once that's enacted. Do you think that can be done, Daisy?
Well, I think it would depend. Sorry, I'm just trying to get up to speed on the facts of it. I mean, I think it will, I hate to put it onto Connor, but it sort of rather goes to the different points at which outline permissions require different stages, and when they engage the extension provisions.
I suppose the question that I have with that one is, if your condition says you have to submit reserved matters by X date, and you have in fact submitted it by X date, then you've discharged, that condition has been dealt with. So you're not, in risk of running out of time. I don't really understand. I mean, I can understand practically speaking, you might have rushed to get the application in, but you got it in on time. It seems to me it would be more sensible for you to speak to the planning authority and have a discussion about submitting further information and saying, look, we rushed to get this in the circumstances, we would like to put a little bit more in. We're aware of legislation coming through. We don't really want to have to withdraw on all of that. And I think they'll take a sensible approach. I wouldn't withdraw and then rely on provisions that you don't know are definitely going to come into effect as they're currently drafted. I think that would be a dangerous approach.
Yeah. And there was a question which could be for either of you or both about how somebody who wants to confirm what would appear to be an automatic extension should go about doing that, just to make sure that they have got certainty that an automatic extension has actually taken effect and the local planning authority realises that?
I don't know, Daisy, if you want to.
I mean, clearly the bill doesn't envisage a need to do so. I think obviously there may be a sort of informal route in terms of just asking the local planning authority for confirmation. I don't think the bill sort of envisages this, and it probably wouldn't be practical for the local planning authority to have to confirm in every case that there is an automatic extension. It might depend slightly on why there is some uncertainty, because it would appear, at least in theory, that it's relatively straightforward to know when there is an automatic extension.
I think, yeah, I mean, I entirely agree. There's no express process for it, but if you're really, really concerned about it and you want some certainty, then I suppose you apply for a certificate of proposed lawful development, and you say, look, this is what we're thinking of doing. We think the permission's still alive. What's your view? And you get it that way. I suppose that's the only formal way you could do it. But I think Daisy's right. I don't think the statute, the provisions envisage everyone doing that.
Yeah, excellent. Moving on then to a different topic, there's a question in relation to the choice of procedure, where we're asked if a party disagrees with the planning inspectorate's choice of procedure, will a review by a senior officer be available?
I think the answer is yes. If you look at the PIN's procedural guide, currently includes a right of review by a senior officer where a decision is made under in respect of what process is to be followed. I see no reason why they would remove that review once these new powers come into force, and indeed I think there's all the more reason for there to be a review process given the potential complexities of these new powers. So I think so, but I think it does touch upon an interesting question of, if you look at the PIN's procedural guide, and I think it's one of the annexes, I think it's maybe Annex K, outlines the types of factors that will be taken into account when deciding what procedure to use. Clearly that's going to need to be revisited in light of the fact that you can now have a hybrid approach. So I think watch this space. There could be some updates to the procedural guide to reflect new powers.
Daisy, have you had any experience of circumstances where procedural choices on the part of the inspectorate have been challenged?
Some, but not to a sort of extreme degree. I think it's always been resolved relatively straightforwardly, in my experience.
I mean, I'm aware of at least a couple of judicial reviews of, yeah. So yes, that could be something which gives rise to some further controversy in the future. We'll see.
But I suppose the only thing to add there is, I think if you were to launch a JR without having gone through the procedural guide process of going to the senior officer, you're not going to get very far, because you haven't really exhausted the internal complaints procedure for it. So you're still going to need to go with the senior officer. If you don't get any truck there, then you might end up on the High Court on it. Yeah.
And looking more widely at this package of reforms, all of the different aspects of it, do either of you two think that they're going to be very controversial in practice, give rise to the scope for court litigation, or do you think people in the circumstances will be willing to let them go, given that they're to deal with the impact of coronavirus?
I would envisage some challenge inevitably, I think, for example, to the extension of construction working hours, which I think could potentially prove quite controversial, where it's having a sort of impact on people. But I do think generally, as sort of perhaps indicated by the relatively easy passage the bill has had so far, there is a sort of recognition that these measures are necessary, and it is obviously sort of very unusual circumstances. So I think we'll have to wait and see, really. Don't know what you think about that, Connor.
Yeah, I entirely agree, and I think the more controversial aspects of the bill are the ones that we perhaps haven't spoken about. So the pavement licenses and the licensing regime, etc. I think those are the ones that are most likely to attract significant parliamentary debate and scrutiny. But I do agree. I think some of the provisions, in particular, some of the interesting questions have highlighted about the construction hours process. There are some legal questions there about its precise scope, and I do think there will be arguments with local planning authorities and not only from those who are applying, but as Daisy alluded to, if there are local residents who feel particularly aggrieved by a local authority who's granting all of these applications without much consultation or without much consideration for residents' views, then perhaps there could be challenges on that front too. So I think there could be some interesting challenges in the future. And on the PINs point, I do think we will all have to seriously consider how we approach planning appeals in light of the sort of hybridization of them. I do think that will cause some challenges to all of us who operate in that field. And indeed, there may well be the need to JR if we feel like wrong decisions have been taken by the inspectorate.
I was just going to add, in relation to sort of the AEA process that I was talking about, I highlighted sort of some of the issues that could arise, which in theory could sort of end up in court. But I wonder whether, because this process is effectively allowing the revival of a permission that's expired, in some sense, it's a slight bonus to be able to do this, because any permissions that have expired during lockdown period, they were getting pretty close to expiring anyway before lockdown. So I wonder slightly whether this won't be the area of a really hard fought battle, to be honest, in terms of the AEA process.
Yeah, and we're asked, some of the audience have been so impressed with your thoughts on this emerging legislation. They want to know what you think about the more significant reforms to the planning system the government's talking about. So I wonder, Daisy and then Connor, whether you just wanted to say something about how you think that might unfold.
Well, I mean, clearly there's going to be, I think any reforms that are made are going to come against the backdrop of this sort of period and the motto of build, 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 and the need to kickstart sort of the economy, the construction sector, and also to get homes built. So I have to admit, I'm not fully up to date on everything, but just in terms of what I was aware of, I think there's going to, I think there was talks of introducing a hard stop of 2023 for local planning authorities introducing local plans. If that's not correct, please do correct me. But so I think that that will be a sort of interesting one to sort of get to a position where all local planning areas do have local plans in place. And also I think we'll see sort of the encouragement, the continuing themes of encouraging building on brownfield sites and a sort of emphasis on that really. So I don't know if Connor has any particular views.
Yeah, I mean, I think you're right. The build, build, build motto, I think, will drive forward a lot of the reforms. I know we're expecting towards the end of the summer a comprehensive policy paper on reform of the planning system. And I do think that will be quite comprehensive given the reports we've seen in the press about potential shifts to zoning and really re-looking at the planning system from first principles. So again, I do think there is potentially more comprehensive reform on the horizon, and we just have to wait and see with that. In terms of what else has been spoken about, as always, when the government talks about changing things with the planning system, there's been discussion about greater use of permitted development rights, and we all have our views on that and how that works out every time it's tried. So I, would expect more, use of permitted development rights, perhaps. But I think all eyes really on the more significant policy paper at the end of the summer to see what we're doing moving forward.
Yes, thank you. Well, if anybody is interested in the future of the planning system more generally, there was a webinar a couple of days ago now where Melissa Murphy and Caroline Daly, I think, gave their thoughts on future planning reform. So that should be available on YouTube for people to watch, as this webinar will be as well. Now, I think the next webinar that we have in our series is happening on Monday, the 6th of July, with Mark Westmoreland-Smith and Hugh Flanagan talking about planning, COVID and viability. So if you would like to watch that, please sign up to do so on our website, but you'll be able to watch it afterwards on YouTube, I expect, if you're not able to do so. So thank you very much indeed for all of those who've joined us, and the great majority of whom are still with us all the way through to the end at 5:30 on a Friday afternoon. So thank you all very much indeed. Goodbye.